The land had been in my family for generations. It sat near a river bordered by old infrastructure that most people ignored. An aging water control system built decades ago for agricultural regulation. It wasn't dramatic, but it was important. And more importantly, it was legally tied to the land deed. For years, nothing happened there. Then one morning, I drove past and froze. Heavy machinery, concrete foundations, survey flags everywhere. A large sign read, "Future site of Riverside Meadows managed by the HOA." I pulled over, heart pounding. At first, I thought it was a mistake. Maybe they crossed a boundary. Maybe they were on neighboring land. They weren't. I contacted the construction office immediately. I showed them copies of the deed, survey maps, and county records proving the land belonged to me. The site manager barely looked at them. "I talked to the HOA," he said. "We have permits." That was the beginning of months of frustration. The HOA claimed they purchased the land through a developer. The developer claimed the title was a clean. Somehow, my land, clearly recorded in county archives, had been ignored, or worse, deliberately overlooked. I sent formal notices. I hired a lawyer. I filed injunctions. The construction didn't stop. Instead, it accelerated. Within months, foundations turned into frames. Frames turned into houses. Roads were paved. Street lights went up. 35 homes stood where my family's land once rested untouched. The HOA attitude was chillingly confident. One representative told me by the time this reaches court, the homes will be finished. Judges don't undo neighborhoods. That's when I realized this wasn't just negligence. It was strategy. They assumed I would back down. But what they didn't know, what almost no one remembered, was that my land carried historic water control rights, rights recorded in the same deed they ignored, rights tied to the old dam system nearby. I didn't rush. I didn't threaten. I gathered documentation, old contracts, government letters, archived engineering records. The dam wasn't about destruction. It was about regulated water flow, legally overseen by land ownership agreements from decades ago. Any change to its operation required authorization from the landholder. That landholder was me. When the case finally reached court, the HOA showed up confident. They brought glossy presentations, community impact statements, and lawyers who spoke like the outcome was already decided. Then my attorney presented the deed. Not just ownership of the land, but ownership of the water rights and control authority connected to it. The courtroom went quiet. The judge paused the proceedings and ordered a full review of historical records. Construction was halted for the first time. The HOA panicked. Homebuyers were already moving in. Mortgages had been signed. Promises had been made. And suddenly, everything stood on land that never belonged to them. This wasn't about money anymore. It was about accountability. The judge ruled that the land was undeniably mine and that the HOA had proceeded with construction despite documented warnings. That alone was devastating for them. But the turning point came with the Water Authority's decision. Because the dam system was legally tied to my property, any adjustment, however minor, required my consent. The HOA had planned drainage systems assuming permanent conditions that were never guaranteed. When I exercised my rights, it wasn't reckless. It followed approved procedures, official notices, and oversight. The system was adjusted exactly as the original regulations allowed. The effect was immediate, not dramatic, not destructive, but undeniable. Inspections revealed the homes were built without proper consideration of land conditions. Permits were issued based on incorrect assumptions. Entire reports had skipped historical data. The HOA tried to shift blame. Developers blamed surveyors. Surveyors blamed outdated maps. Lawyers blamed a clerical confusion. The court didn't accept excuses. The judge's ruling was firm. Property rights were violated. Due process was ignored. Consequences would follow. The HOA was ordered to halt occupancy. Insurance companies pulled coverage. Lenders froze payments. What they thought was a finished project became a legal nightmare. Homeowners were relocated, not because of danger, but because the land ownership dispute made residency legally impossible. It was painful, and I felt for them. They were victims too. But responsibility lay with the HOA that rushed construction instead of resolving ownership first. Eventually, the settlement came not quietly, not cheaply. The HOA was required to compensate for land use, cover legal costs, restore portions of the property, and formally acknowledge the violation of ownership. Some homes were removed. Others were reclassified under new agreements. The development was permanently downsized. Years later, people still ask if I regret standing my ground. I don't. This story isn't about revenge. It's about a system that assumes individuals will give up when pressured by corporations. It's about believing paperwork doesn't matter. It does. Land records matter. History matters. Law matters. And sometimes the quiet rights written in old deeds are stronger than the loudest construction machines.